It's a first for the country. The removal of a head of a Chapter 9 institution is uncharted waters, and the rules of how to handle the inquiry need continuous clarity.
Your contributions and guidance is well appreciated in handling a very important, complex matter for the National Assembly. Hope that you would have been part of starting that important historical journey. But it's very clear that a week later, there might be a few things that we must attend, tighten up, or relook or rethink about.
The meeting so that we can
Public
clarify the
Protector
issue,
Advocate
because the main
Busisiwe
intention is that we've got this
faces
complaint,
charges of
and
incompetence
again,
and misconduct. Some witnesses have come forward willingly or unwillingly to question some of her reports. One witness was accused of drinking whiskey while having medication, while another was accused of lying and dishonesty.
Chairperson, I want to put it on record that during the cross-examination, first of all, of Mr. van Lochrenberg, his medical status was made public for all to see. And secondly, during the cross-examination of Mr. Mkhwebane, there were some really, really horrible insults that were hurled at Mr. Mkhwebane, to the extent that he was called a liar, he was called dishonest, it was absolutely untenable.
The respect should be given to all of us as members of parliament, to the evidence leaders, to the witnesses, to everyone who's involved in this process. So we cannot hurl insult when we can't get our own way. And we want the chairperson to be firm also.
You bring credible witnesses. I'm not insinuating that they are not credible, but I had difficulty in both witnesses who have had. The one was part of the so-called rogue element. You could see that there are gray areas. And also on this one, he says, no, I cannot answer you because I still have a court pending case in court.
The expert witness, there was a shortfall. Maybe we expected too much from the expert witness. We expected the expert witness to focus on what I call alternative dispute resolution.
Other members felt Mkhwebane ought to answer some questions immediately rather than defer them to written responses.
I did become concerned that we are raising questions using Rule 5.9 and accumulating a pile of questions for the public protector before she gives evidence. And some of those questions, most of them, all of them, in fact, that I would have asked, could be posed directly to the public protector in response to her evidence.
When the public protector gives evidence in chief through the chair, that there be a set of criteria to decide if chair can either compel her to answer immediately or allow for her to answer or to consult with her counsel first.
Another member felt the suspended public protector and her defense team were subjected to snide remarks by some members.
One honorable member said it seems as if he's going to be playing a delay tactic and is going to stall the process. You know, something, in my view, that was uncalled for. And it showed that that member is somewhat biased towards the public protector and advocate in both. So if there was fairness from your side, you would deal with such, snide remarks that, erode the confidence that the public ought to have that this indeed will be a fair process.
While there are still legal disputes that are being ironed out behind the scenes, the inquiry is due to meet again in the middle of next week. Meanwhile, Mkhwebane will also challenge her suspension by President Cyril Ramaphosa in the High Court in Cape Town on Monday. Ulelani Philip, SABC News, Parliament.